last case before us is State of Ohio versus Mark Wheeler. The state has waived, and so Mr. Wheeler's counsel, you have 15 minutes.
Thank you, Your Honors. May I please support Ryan Ramage for the appellant Mark Wheeler. This is a case I picked it up on an appointment. I read through it, and I noticed a couple of issues that the trial court, at least one issue that the trial court should have fixed on its own, that is the void sentence, and I'd like to start there. As the Supreme Court stated with Boswell and Simpkins, where a sentence is void, the court is under obligation to have that fixed.
Why don't you start by telling us why the sentence is void?
Okay, the sentence is void. The original charge was as a felony of the first degree failure to verify address. Mr. Wheeler was convicted under Megan's Law rather than the current Adam Walsh Act. Under State versus Howard, which came out about late 2002, early 2012, came out late 2012. The Supreme Court held that as an Adam Walsh, an offender under the Adam Walsh, under Megan's Law could only be punished as the statute held, as statute stood under before the passage of Adam Walsh Act, which at that point made the offense a third degree felony, where the maximum would only have been 3 years rather than a 4 sentenced by the trial court.
So you're saying that Megan's Law provided 3 years, and
yes,
that it was inappropriate or illegal to apply the Adam Walsh Act, which made the offense a 5-year, the penalty of 5 years.
I believe in this case, the sentence handed to the court was 4 years.
Okay, I'm sorry.
So, that's all right. That's all right. The trial court was certainly provided opportunity of this. Mr. Wheeler had filed a motion to withdraw his guilty plea and laid out those exact same grounds to the trial court. He had already priorly appealed that case, and the state argued that because of that it was barred by res judicata. Under Boswell, what the Supreme Court said is when it comes to void sentences, res judicata is no law. A void sentence is a manifest injustice. It has to be removed, and it has to be redone. The rest of my case regards the application of Megan's Law as applies to Mr. Wheeler in this case. His original conviction came from before Megan's Law was passed in Ohio. And he was sentenced to prison. He was brought back to the trial court in 2002 for a classification hearing. He was labeled as the top level sexual predator. At the time of this hearing, he could have come back to the court after his prison sentence or during it if he was able to get that particular help, and he could say to the court, I've been receiving psychological help. I've been speaking with, I'm still in therapy. If Depo-Provera had been a thing then, he could have been gone on that. And he could come back to the court and say, I'm no longer this threat anymore. I can be brought down from the 90 days for the rest of my life.
Well, while he was in prison, did he not have all of those treatment alternatives?
Well, this is from 2002 to 2010. I have no idea what sort of treatments.
Right.
I know with this country we're pretty lax in that.
Well, you said he could have, and I'm just,
Well,
I'm trying to understand the impact of that, because he could have and didn't, potentially.
potentially. It could even have been if the law had stayed as it is when he was finally released in 2010. He could have come out and received the therapy, certainly Depo-Provera or some other medical help, and have been able to come down off of this. Then in 2003, the law was changed. It was no longer a question for the courts whether he was a sexual predator. It was a matter of statute, and he could never come down from that level ever again. So what may have originally been envisioned as the tightest scrutiny for those very much deserving of it, with a chance of redeeming himself at a later point, had now become a permanent albatross across his neck for the rest of his life. And one where he has been required to provide even more and more information, where originally it was, here's where I live, here's where I work, here are the cars that I own, so that way, if the police, if there's a need for the police to come looking for me, they know where to find me. It now became, here's where I live, here's where I work, here's where I go to school. It's in various counties. Instead of having to send it all through the mail, he's now got to go down to the sheriff's office in person. So now, as it applies to him in this case, it has become, as under Hiley and Pratt versus Stewart from the United States Court, where the statutes, where the burden on him has increased and certain rights to him have been denied, it becomes ex post facto applied to him. And also double jeopardy, as again, the statute has increased penalties and increased his burdens. In this case, Your Honor, what I understand, I'm working under the view of the Supreme Court, which has said we love Megan's Law. We've upheld it since Cook, although as time has passed, the Cook's rationales have been removed. Or at the very least, what I would be asking for is resentencing on a void sentence. That's about all I have.
Okay. Any questions from?
No.
Anyone else?
Thank you.
All right. Then, thank you.
Thank you, Your Honor. This is